Like Kurt said, I'm going to talk about the Contractor and Subcontractor Payment Act. If you do commercial construction work in Pennsylvania, you're probably familiar with this act. It's more frequently called CASPA, as we all know it. What happened in 2013? The reality is not too much. There were no amendments to CASPA. There was one case of interest. The case was called Scungio, Borst and Associates versus Schurz Lane Developers and Kenworth 2 LLC. For the reasons we're going to talk about, this case was ultimately withdrawn, but the ramifications and the ideas that the court had kind of placed in this decision before it was withdrawn is an indicator of where the court may be taking CASPA in the future. So we thought that even though the opinion was withdrawn, that it still warranted some discussion. So what we're going to talk about today is a brief summary of CASPA and then the Scungio Borst case. As most folks that deal with CASPA know, this applies to all construction contracts to perform work on real property in Pennsylvania, except when it's preempted by the Commonwealth Procurement Code, which in other words, it's a public job, or if the project involves 6 or fewer residential units. So it's typically a commercial project statute more often than not. What CASPA does, just generally from a 1,000-foot view, is it establishes payment terms and obligations between the various parties, from the owner to the general contractor and the general contractor to its subcontractors and down the line. In the case of an owner and a general contractor, absent payment terms in the contract between the two parties, CASPA establishes what those payment terms are, and it happens to be 20 days from the date of invoice or the end of a billing period. If the contract doesn't discuss what the billing periods are, it's the end of a calendar month. Those terms, again, can be established by contract between the owner and the general contractor. In the case of general contractors and subcontractors and payments to their subcontractors, CASPA requires payments the later of 14 days from receipt of payment or the date of invoice. Despite what we may do in practice, this actually cannot be modified by your subcontract documents. This is what the law requires, and this is when you're supposed to pay. So to the extent that a subcontract does not comply with this, those terms are not going to override the requirements of CASPA. This next point is one of the most often overlooked provisions, but is one of the most important provisions, frankly, particularly from the general contractor standpoint. CASPA requires the disclosure of the due dates for payments from the owner before a subcontract is executed. The reason for that is, if you fail to comply with this provision, most of the subcontracts that are used by the general contractors in this room undoubtedly have pay if paid provisions, which, as you know, says, hey, even if the work is acceptable and compliant, if I don't get paid from the owner, I don't have to pay you, subcontractor. That's a relatively standard provision these days, and they are enforceable in Pennsylvania. Well, CASPA suggests that failure to disclose the payment terms from the owner to the general contractor, you could waive those protections. So as a practice tip, I think it makes sense to attach as a rider to your subcontracts the payment terms that you have with the general contractor and the owner. Again, you don't have to, I know there's a reservation of folks that don't want to do that. You don't have to disclose amounts. What's important is the timing of the payments. So there's really no reason not to provide that information, particularly if you want to rely on the protections that CASPA affords you. Again, CASPA is a payment term provision in terms of when you have to make payments as it relates to timing. It doesn't mandate that payments have to be made if the work isn't any good. So CASPA allows payments to be withheld by both general contractors and subcontractors and owners for deficiency items. Deficiency item is, as you would expect, is defined as work not completed in accordance with the specifications. If this occurs, the important part that we need to take away from this is whether you're a general contractor, owner, subcontractor, you have to provide notice within 7 days of the invoice for the deficient work. Otherwise, you're risking violating CASPA. As it relates to retainage, retainage must be released from the owner to the general contractor within 30 days of final completion, and from a general contractor and subcontractors to their subs within 14 days of receipt of payment. These provisions cannot be modified by your contract terms. This is what CASPA requires. The only way to withhold retainage after these after final completion is for a deficiency item. And again, that must be, you must provide written notice, so that's the reason for your withholding. Failure to disclose your payment terms, provide notice of a deficiency, or to release retainage can waive certain defenses under CASPA. Most importantly, again, we highlighted earlier, was the pay if paid protection that is often afforded to general contractors. Violation of the applicable payment terms requires a mandatory 1% interest, and it also could result in a 1% penalty if the case actually ensues to litigation and the party claiming the right to payment is successful. As those of you who know that are involved in litigation on construction projects, they often can drag on for years or longer sometimes. So 2% a month can add up pretty quickly. So it's important that you comply with the notice requirements under CASPA to make sure that you're affording yourself all of the protections that it gives you. Lastly, the substantially prevailing party shall be awarded reasonable attorney's fees. It says shall, but those of us who have experience with CASPA knows that it's very uncommon and it's not likely that attorney's fees are awarded at the end of the construction litigation. So that was just an overview of CASPA. Again, it's the payment application that applies probably to more projects than anything else, so we thought it warranted some discussion. As it relates to case law this year, there was one case that we thought was of interest, and it's Scungio Borst and Associates versus Schurz Lane Developers and Kenworth 2 LLC. This case involved a $3.8 million condominium construction project. I believe it was in Philadelphia County. General contractor filed a lawsuit against the development company as well as its 50% shareholder in his personal capacity, seeking $1.5 million in unpaid change orders as well as CASPA damages. The shareholder, at the trial court level, the shareholder filed a motion for summary judgment, which was granted by the court, essentially dismissing the shareholder from the case. The case proceeded to trial between the contractor and the two development companies, and the contractor was ultimately awarded a $1.9 million judgment against the defendants. Despite being the winning party at trial, the contractor actually filed the appeal, challenging the summary judgment that was awarded in favor of the shareholder. The opinion is not clear, but what we assume to be the case is there's likely a mortgage or a construction loan against the property, so the judgment against the development company, it's likely a single asset entity, is probably second in priority and doesn't have much value. So in order to collect this judgment, they need personal liability against the shareholder. So they filed this appeal. And the basis of the appeal essentially is that the contractor is claiming that the owner is actually, or the shareholder is actually an owner, as that term is defined within CASPA, which makes him directly liable for the CASPA violations. Again, just briefly, just to get some context to this, we'll go over some of the facts of the case. Essentially, the contractor was performing its work on the job, the work was proceeding, payments were coming in. At some point in time, payments stopped being made to the contractor. Obviously, general contractor is concerned when that occurs, begins talking to the shareholder who was active in the project and regularly on site, and saying, hey, I'm doing my work, where are the payments coming? And according to the opinion, the shareholder was giving him assurances that payment would be forthcoming, just keep doing your work, the money's gonna be there, go ahead and keep working. Contractor relied on those promises and continued its work. Subsequent to that, there were some additional changes and add-ons to the project. The shareholder again said, money's coming, go ahead, do the work, we know that it's extra work, go ahead and do it, and the contractor relied, and he kept conforming. At some point in time, and the opinion's not clear, the contractor was terminated and the project was shut down. Contractor filed the lawsuit that we're discussing, claiming that the shareholder was an active participant in the project and was making promises that should bind himself and the company, and filed a lawsuit in his personal capacity. The shareholder, as you would expect, claimed, I'm not a party to this contractor or this contract, I just have an interest in the company. I can't personally be responsible for any dispute or unpaid amounts between the development company and the contractor. There are two main issues in the case. One is that is the shareholder personally liable as an owner, as that term is defined within CASPA? And the court's answer to that is maybe. And the second is, was the construction contract orally modified by the shareholder's promises, despite the fact that the subcontract required, or the general contract, I'm sorry, required change orders to be in writing? Again, the court's answer is maybe. Essentially, the important part of the issue relating to the owner is the definition of owner under CASPA, a person who has an interest in real property that is improved and who ordered the improvement to be made. The term includes successors in interest of the owner and agents of the owner acting with their authority. That language there in bold is what's important to the opinion here. Is the court found that the shareholder's active involvement in the project could make him an owner under CASPA as an agent acting with their authority. The court ultimately ended up remanding this case on a technicality, but the gist of it is, hey, we're acknowledging that you, an active shareholder, can be an owner under the definition of CASPA. The case was remanded for determination of fact as to whether or not he actually was acting with the authority that CASPA requires. The second issue is whether or not the oral promises that were being made without written change orders could modify the contract. In essence, this is pretty established law in Pennsylvania, so this isn't something that was new. Pennsylvania, even if a contract has a no oral modification provision or requires written change orders, the Pennsylvania laws that allows that the contract can in fact be modified. Essentially, if the owner is requesting extra work, promises to pay for it, watches a contractor perform the work, and then ultimately doesn't pay. That was nothing new in this case, but that was one of the issues. The court remanded it again to determine whether or not the contractor in fact made those promises. The court's decision, like we said, it was reversed on a technicality. There were questions of fact as to whether or not the owner had the authority, or the shareholder had the authority of the development company to bind it, and whether or not it in fact made promises orally to change the contract. This case, there was one of the judges, it's a three-panel court decided this. One of the judges filed a dissenting opinion saying this isn't how CASPA is supposed to apply. An owner, somebody that's acting on behalf of the owner is not necessarily binding himself personally. As I indicated, the case was withdrawn. The losing party, the shareholder, filed a motion for reconsideration, which the Superior Court granted. So the case is actually going to be heard by a full panel of the court, we assume sometime in this coming year, and an opinion will be released at that point in time. Our takeaways, again, confirming that you have to be careful what you do on the project, because if you have authority to bind the company, your oral promises can bind the company, even though the contract requires a written modification. And secondly, and this is the thing that got a lot of interest from this case, is the fact that a shareholder or an agent of the owner can actually be personally liable as an owner under CASPA. Again, this is foreshadowing. Whether or not the court is going to come down in this way again, we don't know. The opinion has been withdrawn, so keep in mind this is not the law as it stands now. But where it's important is it's possible that principals of a corporate entity, who are typically have the corporate shield that we all know and recognize, could be liable if they are interacting with contract personnel on site and making promises. Second, and probably more importantly from a practical standpoint, is what effect is this going to have on project superintendents or other folks that are acting with the clear authority of the owner on the projects? Are they going to be personally liable? That's one of the concerns that this opinion had. Again, it's going to be heard by a full panel of the court, so we'll see what happens in that regard.